there's a substantial probability that such person's presence would impair the conduct of a fair trial. So I guess there's a two-part question. Is he, as the non-legalized or legitimated father, the immediate family of the victim? And then, I mean, you do agree he's a material witness, I assume?
Yes, he is a material witness. There's no doubt about that.
Well, then I guess you should address those two issues, whether he is a family member under the statute and whether there's a substantial probability that his presence would impair the conduct of a fair trial.
Under the statute, Judge, under 1717.3, paragraph 11, it says victim means a person against whom a crime has been perpetrated. In the event of the death of the victim, the following relations, if the relation is not either in custody for an offense or the defendant, of course he's not in custody, he's not the defendant, a spouse, an adult child, a parent, a sibling, or a grandparent. Now, it says a parent. It doesn't define further what a parent is. What I will say is this: is that if Julian Williams is not recognized and permitted to remain in the role of the victim's representative in this case, then this victim is unrepresented entirely with regard to this case. With regard to whether or not it would impair the conduct of a fair trial, what I will tell the court is this: is that as it stands right here, that the testimony that I expect that will precede Julian Williams' testimony is essentially testimony regarding the crime scene. Okay, in other words, where the area, the dorm, that area was secured, where James Gibson from the GBI will testify about the specifics of that. There'll be some photographs, etc. Chief Lewis from GSW will testify about nothing other than the times via video, the times that Julian Williams and the defendant entered and exited the dorm. And I mean, that will be the entire substance of his testimony, will be to establish those times. And then I expect Julian Williams to be my next witness after that. So it's essentially just, preliminary testimony sort of to set the scene and that kind of thing is all that he would, is all that he would be in the courtroom to hear. So I don't think that he may be a material witness. I don't think his presence would impair the conduct of a fair trial.
All right, Mr. Gamble, I'll let you have the last word.
Well, Your Honor, unless we're going to set the entire Georgia legal code on its head, it's clear that you must be legally recognized as a father. As an example, a father that's done everything in the world for a child, paid child support even in Georgia law because he's been proven to be biologically the father that is not legitimated, has no legal rights to that child at all. No visitation rights, no right to custody. If he takes that child somewhere, can be charged with kidnapping if he does not have permission. The law is clear that it's not recognized.
How would you like you to address the substantial likelihood that it would impair the possibility of a fair trial?
The substantial likelihood is even more clear, Your Honor, in that this witness, once he testifies, I mean, even if he's the first person to testify, he's subject to recall. We would not be in favor of allowing him to be in the courtroom. And the substance of this case involves Trinity Poague being accused of doing harm to a child. There were only two people around that child at the time period they're talking about this occurred. Her and Julian Williams. And Julian Williams is a substantial evidentiary person in this case and is subject to much more testimony than what the state may be trying to elicit, and told several different stories to the GBI during the time that he was interrogated.
Are you contending that even after he testifies he would not be allowed in the courtroom?
If he is subject to being recalled, Your Honor.
Or do you have him under subpoena?
I do have him under subpoena, Your
All right.
Whether he has him under subpoena or not, Judge, his subpoena is satisfied once Julian Williams takes a stand, and which he will do this morning sometime.
What's the second issue? Of course, I wish we had brought these up yesterday when we didn't have a jury in the jury room.
Yes, sir. I mean, I'm sorry.
That's all right, but what's the second issue?
7:45 when we were done.
I know.
So,
What is the second issue?
The second issue is a very brief motion in limine regarding opening statements, and that is that the law only permits in opening statements a statement or to the jury, an expectation of what evidence will be presented to the jury. And so I would object to or ask the court to instruct Mr. Gamble not to make any reference to any statements that were made by his client, by the defendant, to Samantha Fort of the GBI. And that's because he's not going to he can't put those statements in evidence. It's hearsay for the defendant to put in his or her own prior statements made outside the courtroom. So he can't put them into evidence. And I am not, I don't know whether I'm going to or not. I mean, I don't anticipate, at this point, I don't anticipate that I will do so.
So your motion in limine is for him to not put his client's statements to the GBI
right,
into evidence
she
in
told
opening.
the GBI this, and this.
Okay. Mr. Gamble?
I don't intend to do that, Your Honor. That's fine.
Well, then I'll grant that motion in limine. What I'm going to do with regard to Mr. Humphreys is, because, Mr. Williams, is without having a definition of what is meant by parent in that statute, I'm going to exclude his testimony, exclude his presence until after he testifies. Once he testifies, I'm likely to allow him to remain in the courtroom as a representative of the family and based upon the fact that he's already testified. All right. Are all the jurors here? All right, let's take 5 minutes, and if anybody needs to step to the restroom, let's do that, and then we'll begin opening statements.